Fourth of 5 panels for today's one-day law school for journalists. Uh, please make sure that you put any questions in the Q&A. We are doing our best to try to answer them either through the panel or I'm just completing a response. We will also follow this program with an email to you with the materials, resources, and finally, all the panels are being recorded and will be made available on PMC's website, www.pmconline.org. So thank you, Eli and Chris, for presenting, and I'm hoping you can each introduce yourselves and let's start. Thank you.
I'm Eli Segal. I'm a partner at the law firm of Stapleton, Segal, and Cochran. In my practice, I am a litigator, and roughly half of what I do ends up being First Amendment work of one kind or another. So I deal a lot with journalists, helping them when they're sued for defamation, helping them when they're trying to get access to information to write about in the first place, and also helping them when they find themselves on the other side of a subpoena or request for information about their news gathering materials or sources. And that's what we're going to talk about today. So, Chris, do you want to introduce yourself?
Sure thing. Hi, I'm Chris Brennan. I'm a national columnist for USA Today. And before that, I was at the Philadelphia Daily News and the Philadelphia Inquirer for a combined 24 years. And I highly recommend Eli if you find yourself in a First Amendment pinch. Heck of a lawyer.
Thanks, Chris. So we're going to talk today about the journalist's privilege, which I use to broadly refer to the privilege that may or may not apply depending on the situation, to keep you from having to give up your news gathering materials or information. Whether it applies and the extent to which it applies depends in part on whether you're in state court or federal court, whether New Jersey law applies, whether Pennsylvania law applies, whether you're left to rely on the First Amendment. We're going to sort of talk through the intricacies of the doctrine today. Going to start by talking about the things that you might want to protect. Then we'll talk about where those things might be sought. So what types of proceedings. We'll talk about the rationales for protection of your news gathering materials and the information. And then we'll get into the meat of it, which is the sources of the protections that might be available to you. And we're going to talk about the First Amendment. We're going to talk about a Pennsylvania statute, and we're going to talk about a New Jersey statute and go into some detail on the ins and outs of each of those. Then we're going to talk about a few practical examples. I'm going to talk about if you find yourself as a defamation defendant, where news gathering materials and information are sought. If you find yourself having covered a story that's implicated by a murder trial, and if you find yourself the subject of a grand jury leak investigation. And then I'm going to turn it over to Chris, who's going to talk about his very practical experience having dealt with these issues, one of which was a grand jury leak investigation. And I think he has 3 different types of scenarios that'll all be probably more interesting than what I have to say, and certainly informative of what you might be thinking and what you might do if you find yourself in a jam on one of these issues. So let's start with what information and materials you might want to protect. You might want to protect the identities, or you will want to protect the identities of your confidential sources. You have communications with sources, recordings, notes, research materials, drafts, communications with fellow reporters and editors, in your editorial process and decision-making process. I tried to cover everything that you might sort of create in connection or gather in connection with doing your reporting. And all of this is potentially fair game in a lawsuit or a criminal investigation to the extent that is relevant, unless you have some sort of privilege that you can invoke to push back on it. Start with the identity of a confidential source. This is really sort of the most important thing and sacrosanct. It's also something that the U.S. Supreme Court has said it rises to the level of a contract. So you make an agreement with the source that you're not going to out who they are. You are bound to continue to do that. And if you break that agreement, you could be sued for breach of contract. Communications with sources. This could be emails, text messages, WhatsApp messages, signal messages. Recordings could be audio recordings that you make of your interviews, video that you take, photos that you take. Your notes are some people use traditional reporters' notebooks and have tons of them sitting in their office. Some people take their notes on their iPhone. Some people take their notes on their computer. Research materials could be something that you get from a source, something that you find on your own online, primary source documents that you look at, a court opinion, a piece of legislation, really sort of anything that you might gather in researching your story. We know that people often write multiple drafts of stories, and now publication software sometimes will save hundreds of drafts, every second, every minute, resaving it. So can be a lot of material there. Communications with fellow reporters and editors. I've dealt with a lot of defamation cases where a lot of the key evidence ends up being Slack messages, Teams messages, text messages that reporters send to each other in the midst of reporting on a story. And then there's editorial decision making and the process. So where did a story come from? How did you research it? How did you write it? How was it edited? Why did you include certain items in the story? Why did you make certain edits to the story? Why did you choose not to publish a story that you worked on in the first place for a while? So all of this is, I consider to be news gathering information and materials, presumably that you would want to protect, and that to the extent it's relevant, somebody might want to try to get. So where could they try to get it? Somebody could try to get it in civil litigation, and this could be state or federal. So we have state court, we have federal court. Federal court claims can be based on federal claims. So if you have a claim based on a federal statute, or if the parties are from different states and there's a decent amount of money at issue, you can bring a state law claim. So a defamation claim can end up being brought in state court, or it can end up being brought in federal court. Add on to that the complicating factor that then you need to figure out what law applies. Is it state law? Is it federal law? And if it's a state law, what state's law applies? And this is going to end up mattering a little bit because depending on what state's law applies, the level of protection you might get is a little bit different. We're not going to get too into those details, but know you could find yourself in a lawsuit in state court or federal court. And if you're a party, meaning if you're a plaintiff or more likely a defendant, you can be subject to demands and notices from the opposing party for written discovery, for documents, for deposition testimony, for trial testimony. So let's talk through sort of an example. Say you're a defendant in a defamation case. You could be served with requests for admissions. So you could be asked to admit that John was the source for the statement that you made in your story. You could be asked interrogatories, which are written questions. So you could be asked to list all the steps that you took in reporting your story, in researching your story, in editing your story. You could be asked to list everybody who was involved in your story. You could be subject to document demands, and documents is broadly construed. So this means really anything that records information, whether it's written or electronic. So you could be asked for your communications with your sources. You could be asked for internal communications. You could be asked for notes, for drafts, for recordings, for your research materials. You could also be asked to sit for a deposition, which means being asked questions under oath out of court as if you were in court. And then, of course, if your case goes to trial, you could be called as a witness to give trial testimony under oath. If you're a third party, you could also be subject to requests for your news gathering information and materials. By third party, I mean you're not the plaintiff or a defendant. You just happen to have knowledge that relates to what's going on. So for example, a customer sues a businessman for fraud, and you happen to have written a story about the businessman before. The defendant or the plaintiff can issue a subpoena. It means something that has the power of the court to compel you to do what's being asked. So they can issue a subpoena for you to provide documents, again, broadly construed, relating to your article, or to sit for testimony either at a deposition or at trial to testify about your article. There's also criminal proceedings where you could be asked for your information. Those, again, could be state or federal, and there you could have the government or the defense issuing a subpoena to ask you to provide documents, to ask you to provide testimony. And you could also be subject to requests for information or demands for information in grand jury proceedings. Grand jury proceedings can be investigative, they can be indicting grand juries, but they're mechanisms through which the government investigates and looks for information about potential crimes. Chris will talk about this a little bit, and there can be state and federal, and again, there's the power for to issue subpoenas that the government has. So you could be asked again or demanded to provide documents and to provide testimony. So we've talked about the things you might want to protect and where those might be vulnerable. And what's the reason why you should have protection in the first place? I think a lot of us or a lot of journalists sort of just think inherently there's something that's sacrosanct about their journalism, but sometimes it's important to articulate it. So we've got this foundational principle that the free flow of information to the public is crucial for our democracy, right? In order to be informed citizens, we need to know about what's going on, because how can we act in an informed way if we don't know what's up? And the press is the key avenue for making sure that all of us can know what's going on. And the thought is that you can maximize this free flow of information to the public by one, allowing journalists to promise confidentiality to sources who might not otherwise share information. And that's sort of the one that we often think of, right? There's someone out there who wants to speak, but feels that they can't speak without being subject to some sort of retribution. A journalist, we think, or I think, needs to be able to offer confidentiality to that source and say, hey, you can tell me your information. I won't let anybody know who you are, where I got the information from. And we're all the wiser for it because that leads to information going to the public that otherwise might not have been there. And there's this other sense that even when you're not talking about a confidential source, that it's better for all of us to allow there to be a zone of privacy and integrity around the journalistic, news gathering, and editorial process. We're going to get better information. We're going to get more information if we leave sort of a sphere for journalists to operate without thinking that everybody is looking over their shoulder. There's some dispute over that. I think that's a less compelling argument than the argument for protecting confidential sources, but I think it's an important one nonetheless. So you want to have protection. Where can you look for protection? There's no federal statute that exists that protects journalists. So from a federal law perspective, we need to look to the First Amendment, which is some 50 words and says nothing about protecting news gathering materials or sources. There's a reference to free speech. There's a reference to free press. But the text is unclear and there's no clear U.S. Supreme Court authority on it either. So what you do is you look to the Court of Appeals in your geographic area. And for us, that's the U.S. Court of Appeals for the Third Circuit. Comes up with the interpretation of the First Amendment that's binding on courts in Pennsylvania and New Jersey and Delaware. So that's one source. In Pennsylvania, there's the Pennsylvania Shield Law. And in New Jersey, there's the New Jersey Shield Law. And we're going to look at each of those. So the First Amendment, who does it apply to? Applies to a person engaged in gathering and investigating news with the intent to disseminate it to the public. So it's a pretty, basic definition. Key in there, and there's been cases that have got off on the idea that you need to be intending to disseminate the information that you're gathering. You need to be intending to disseminate that to the public. Questions come up about, what does this mean for non-traditional media, websites? Those, for the most part, have been protected. It gets a little bit dicier when you're talking about an independent journalist. So you're working on your own, you're putting something out there on social media, you're relying on sources. The law is unfortunately not clear. So where does this First Amendment privilege apply? It applies in all proceedings. So whether we're talking about state court or federal court, civil, criminal, or grand jury, the First Amendment is a limit on what government can do at the federal level and state level, and that includes a limit on what courts can do. So anywhere you find yourself, you're going to be able to invoke the First Amendment journalist privilege. And what does it apply to? It applies to everything about your news gathering. So the identity of a confidential source and also all of your other news gathering. But there's an important limitation. This is a qualified privilege. What that means is it can be pierced, so you can invoke it, but then the other side gets a shot at showing why your privilege should give in to their need for information in that particular situation. And the Third Circuit has said there's a three-part test that you need to satisfy in order to get the information. You need to show you tried to get it from somewhere else. You need to show that it's only available through the journalist. And you need to show that information is really crucial to whatever the proceeding is that's going on. So something's crucial if you're the plaintiff and it goes to an element of your claim. It's crucial if you're a defendant, if it goes to an element of your defense. It's crucial to the government if it helps show somebody is guilty. It's crucial to a criminal defendant if it helps show that they're innocent. And it's crucial, I'd say, to a grand jury proceeding if it goes to the heart of what it is that's being investigated. But it's on whoever it is that's seeking the information to try to pierce the privilege and make this showing. There's a few other sort of plus factors that can tip the scales. If we're talking about a criminal case as opposed to a civil case, the privilege is more likely to yield. The idea is that in a criminal case, you've got the right of the defendant to a fair trial, which involves getting all of the relevant information. So that's sort of a countervailing interest that cuts against the privilege and can tilt the scales. And you also have the government's interest in a criminal case in solving crimes and in bringing people to justice. If you are a party to a case as opposed to a non-party, the privilege is a bit weaker also. The thought being that we're less likely to want courts to intrude on non-parties, so someone that's sort of on the side, than we are to allow courts to intrude on an actual party. And when what we're talking about is not the identity of a confidential source, this First Amendment privilege is more likely to yield. So let's turn to the Pennsylvania Shield Law. Pennsylvania Shield Law applies to any person engaged on, connected with, or employed by a newspaper of general circulation or any press association, any radio or television station, any magazine of general circulation for the purpose of gathering, procuring, compiling, editing, or publishing news. So again, pretty broad, and it's been interpreted to include traditional media, non-traditional media, but again, you've got the situation of the independent journalist where the law is not quite clear. Where does it apply? It applies to civil lawsuits that are raising Pennsylvania claims. So if you're sued in federal court or in state court, and the judge determines that the law that governs is the law of Pennsylvania, then the Pennsylvania Shield Law would apply. So generally, if you're sued for defamation by somebody who lives in Pennsylvania, you're going to be looking to the Pennsylvania Shield Law. And it also applies in Pennsylvania criminal and grand jury proceedings. So what does it apply to? It's very, very limited. It only applies to information that could lead to the discovery of the identity of a confidential source. So you wrote a story, you relied on a confidential source, you say according to sources X, right? And that source is confidential. You don't have to disclose who that person was. You don't have to disclose information that could help lead to the discovery of who that person was. All your other news gathering materials, your notes, your drafts, your conversations with non-confidential sources, your conversations with your colleagues about non-confidential sources, all of that is fair game under the Pennsylvania Shield Law. And when can it be overcome? Never. It's absolute. So there's no balancing test like with the First Amendment privilege. If you have a confidential source who you relied on and Pennsylvania law applies, you do not need to do anything that could lead to the discovery of that source's identity. And I know Chris has personal experience with this. New Jersey. Again, there's a pretty broad definition of who the privilege applies to. Again, it's been applied to new media, and it's still not entirely clear what the deal is with independent journalists. And this is sort of a theme throughout. There's a lack of clarity in the law. So if you're a journalist trying to figure out what to do in advance, it's often hard to predict what type of proceeding might you end up in, what law is going to apply, are you going to be covered by the privilege or not? You can sort of do the best you can to be educated on the issues and know that to some degree there's an element of chance that you're subjecting yourself to. So the idea of making a commitment to a confidential source to keep their identity confidential, I know that's sort of taught in journalism school and also from a legal perspective, that's a big commitment with big consequences. And an important one to be able to make, but one that again has consequences that you can't necessarily game out ahead of time because you don't know whether you're going to find yourself in a criminal proceeding, in a grand jury proceeding, in a defamation proceeding. You don't know whether New Jersey or Pennsylvania or federal law is going to apply. You might not be able to anticipate whether you're going to be considered to be a journalist. It's just, there's a lot out there that is not particularly clear. The New Jersey Shield Law applies to civil lawsuits raising New Jersey claims and to New Jersey criminal and grand jury proceedings. So what does it apply to? So the New Jersey Shield Law is really broad. It applies to anything that could reveal the identity of a confidential source. And it also applies to all of your other news gatherings. So all that other stuff that we talked about, your notes, your recordings, your communications with your colleagues, with non-confidential sources. When the New Jersey Shield Law applies, you really don't have to testify at all about your journalism unless you decide you want to. And when can it be overcome? In a civil case, never. In a criminal case, there is a limited situation where it can be overcome. So if the defense shows that it's relevant material and necessary to the defense, that there's no less intrusive source, that the value for guilt and innocence outweighs the privilege, and that it's not overbroad, oppressive, or unreasonably burdensome. Basically, the idea is that where the defendant's right to a fair trial will be jeopardized by your unwillingness to disclose your journalist materials, the privilege can yield in New Jersey. So, for example, if you have information suggesting that someone other than the criminal defendant committed the crime, you may be forced, even under New Jersey law, which is pretty broad, to out your source and give up that information. So let's talk about a few examples because we've gone through sort of the meat of this. And I think it's worth talking through how these may play out differently depending on what law applies and what exact sort of information is at issue. So let's say you are, and this is sort of probably the most common situation where someone ends up seeking your journalistic materials, your news gathering materials. You're sued for defamation, and you're asked to disclose the identity of a confidential source and say the key alleged defamatory statement in the story is based on something that came from a confidential source. So you reported that a police officer engaged in sexual misconduct, right? And you had a confidential source who told you that. And the defamation claim is, hey, that's not true. And you knew it wasn't true or should have known it wasn't true. If you're talking under Pennsylvania law, you got the right to not disclose the identity of your confidential source. So that means if you're asked to provide documents in the case and you have an email from the confidential source, you can redact the source's name. If there's anything in the body of that email that would otherwise disclose the identity of the source, you can redact that or withhold the whole document. You can refuse to provide copies of original documents that you got from the source because they might show fingerprints, which could be used to identify the source. You can refuse to answer questions asking you to sort of narrow things down, right? You can't be asked, was it this person? Was it that person? Was it this person? Was it that person? And there's really no other sort of substantial narrowing down that is allowed to be done. So the lawyer on the other side can't try to get you to narrow down to sort of what specific department within the specific office the person worked at. The idea being that if you can limit it down to 10 people or 5 people or 3 people, that in and of itself can cut against the confidentiality of the source. Now, the consequences for a defamation case are that it could be a little bit harder to defend, right? If you're being accused of having made up the fact that a supposed confidential source told you that a police officer engaged in sexual misconduct. If you could get up there and say, no, I was told that by this particular person within the police department, and then you call that person to testify, you could be in better footing in defending against the case, right? You're not subject to claims that you sort of made everything up. But again, if you've made that commitment to your source, sort of left to deal with the consequences. But under Pennsylvania law, you would not need to reveal the identity of the source. Under New Jersey law, you would not be required to reveal the identity of the source. And under federal law, it gets a little bit more complicated because we're dealing with that balancing test. And it sort of comes down to whether this information is crucial to the other side's claim. I don't know of any situations in which in the Third Circuit, even applying federal law, someone has been ordered to reveal their confidential source. But it's just not as clear as the landscape under the New Jersey statute and the Pennsylvania statute. What if you're asked for other news gathering for the publication at issue? So if you're asked for your drafts, if you're asked for your communications with your non-confidential sources, if you're asked for communications with your colleagues, Pennsylvania law, you'd have to provide that. New Jersey law, you wouldn't have to provide that. Federal law, you probably would have to provide that. Again, it sort of depends on which law applies and what particular materials are at issue. You might also be asked, say, again, it's a report of alleged sexual misconduct by a police captain, and you might be asked for everything that you did in reporting on that captain in other contexts, right? So you say you wrote some other series of stories about the captain. Pennsylvania law, you wouldn't have any protection for that. New Jersey, you would. Under federal law, it starts to get a little bit further afield, right? It's less core to the claim that's being raised against you. So you'd be looking at the balancing test. So you're talking about a murder prosecution. The identity of a confidential source, and I think it's sort of, we've got to look at a few different possible scenarios. So one, you've got a confidential source who says he has firsthand knowledge that the defendant didn't do it, right? Like amazing exculpatory evidence for the defense. Pennsylvania law, you don't have to give up the name because it's your confidential source. Under New Jersey law, you may because it starts to conflict with the defendant's right to a fair trial. And under federal law, it's a balancing test where you're a little bit more vulnerable. If you're talking about a source who says that the defendant did it, then you don't have the right to a fair trial. That's at issue. It's information that will be helpful to the government, not to the defendant. And you end up in a situation where under Pennsylvania law, you wouldn't have to provide the information. Under New Jersey law, you still wouldn't. And under federal law, again, it's unclear. And this is not meant for you to sort of take this away and memorize exactly what applies when, but just to know like it's complicated. And it depends on whether you've got confidential sources that are issue or not. It depends whether what law applies. It depends in part whether it's civil or criminal. It depends in part whether the right of the accused to a fair trial is implicated. So there's this web of factors that all sort of complicate the situation. And then let's talk briefly, and I know Chris will talk more about this, a grand jury investigation into a leak. So lots of reporting is based on people having leaked information that they were prohibited by law from having leaked. And occasionally there are grand jury investigations that are conducted to try to figure out who did the leaking. And in this sort of investigation, you could be asked for your communications with the leaker, showing the name of the leaker. You could be asked for your notes, your conversations with the leaker, a recording of your conversations with the leaker, copy of documents that have the leaker's fingerprints on it. I know that happened with Chris. And you could be asked to give testimony about the identity of the leaker. And this, again, it depends on where you are. In Pennsylvania law, if it's a Pennsylvania criminal grand jury, you're going to be golden. If it's a New Jersey grand jury, you're going to be golden. If you're talking about federal law, it gets more complicated. And that's where you have situations like Judith Miller, who it was determined found out information regarding the identity of a CIA agent. She was called before a grand jury. She refused to testify. The court found that there was no privilege that applied there under the First Amendment. And she went to jail for many days and ultimately was released when the source outed himself. But again, if she had been subject to a grand jury in Pennsylvania, the outcome would have been different. So the upshot of all of this is that there is a good amount of protection to draw on. That if you're asked for your news gathering materials or information and you feel queasy about it, that makes sense. And it makes sense to talk to a lawyer and to think about and make sure the lawyer thinks about where are you? What's the context? How is it that this information is relevant? Are you in state court? Are you in federal court? Is it criminal? Is it civil? There's a lot of complicating factors to consider here. The upshot is that the landscape is not particularly clear, but there's some guideposts that you can look at to try to make the best effort you possibly can to protect your information. So with that sort of overview of the law, I'm going to turn it to Chris, who's going to talk about his direct experience with actually having dealt with this stuff.
Thanks, Eli. So I've experienced this and invoked the Pennsylvania Shield Law in 3 different cases involving 2 different grand juries. The first happened way back in 2007 when Kitty Caparella, the organized crime reporter at the Philadelphia Daily News, and I broke a story about a Scranton area casino owner who was under grand jury investigation in Dauphin County for allegedly lying on his application to become a casino owner about whether or not he had connections with organized crime members. And we broke that story, and the Inquirer followed our reporting on it, and then the Morning Call, and at the time, the casino owner had a very politically connected lawyer who convinced the Pennsylvania Supreme Court to appoint a special prosecutor to look into how we got our information. And there were everything you would expect from that: subpoenas for testimony, subpoenas for notes, um, subpoenas for, requests for us to reveal confidential informant information. And ultimately, we agreed to provide them with some notes that didn't disclose any confidential information. Actually, back then, I mean, this is in 2007, before I started using audio recorders. I could barely read my own notes by the time they were subpoenaed a couple of years later. Um, but in the end, that was the basis for a report from the special prosecutor, which did not reveal who any informants were. Ultimately, he wound up criticizing the Dauphin County District Attorney's Office for uh, posting the hours that grand juries met on their website, and also for um, having the grand jury room, um, where the witnesses came and went, located in a public hallway, which had a bench, which I sat on for many hours for several days, just taking note of who went in and who came out, and what, if anything, they would say. So that was the first case. Um, the second case was uh, also grand jury material. That was former Pennsylvania Attorney General Kathleen Kane eventually got convicted in this case, but a source provided me with some information um, about a case that had been investigation that had been run by a predecessor of hers about a person in Philadelphia who, and that case had not um, resulted in any charges against that person, um, even though it was a pretty extensive investigation. And the Daily News I wrote a story for the Daily News about that case, which first went to a grand jury. I was called to the grand jury twice, and asked to reveal where I got the information. I refused both times. I was asked some questions that I could answer because they were out there. There were things that were in the story. They were they weren't they didn't involve confidential information. But for the most part, the things they really wanted me to reveal, I refused to. And then later on, when Kathleen Kane was on trial, I was called as a witness, and again asked twice on the stand if I would reveal who my source of information was, and I refused both times. And each time it was the Pennsylvania Shield Law that I invoked, because I had promised confidentiality to sources, and I believe in keeping my word when I do that, and always have and have to. I mean, in order for newspapers to function, reporters have to be able to uh, promise people confidentiality. There are people who won't talk to journalists without that, and when people stop talking to journalists, journalism stops working.
There's a few questions in the Q&A
Okay.
about these confidential informants. And the one was, does the person need to write like confidential informant in their notes? How, like, if your notes are subpoenaed, do you redact things? Just how do you designate, right, what's from confidential informant versus what you've received from other kinds of sources?
Well, I can tell you from my own practice, I designate in notes
Okay.
if something's off the record, if something's on background, if something can't be revealed. And that's a good idea, even if you never get a subpoena, because some stories go on for weeks or months or years. And if you're gonna hang on to your notes, you're gonna you're gonna want to remember uh, when you told somebody that you were speaking off the record or on background, or if it's, some level of confidentiality. So I think it's prudent to note that in your notes, just so say like a month later you go back and you're looking at something, um, you don't have to wonder whether or not
Right.
that information was off the record. Because you noted it that way.
And so there's no legal requirement to do it. It just makes things a whole lot easier, right?
Yeah.
Like Chris said, there's the passage of time. Um, and I've had cases where there is defamation that was alleged as to say, 20 different articles, and then a reporter showed up with a duffel bag full of handwritten notes, right? And then we end up spending hours and hours and hours going through all these notes trying to figure out what was and wasn't confidential. It can be sort of mechanically, it can be complicated. So you can redact, right? Sometimes redacting is impossible because there are things within the notes that might otherwise identify who the person was, right? Like sort of unique things that only that person would know. Um, Sometimes you'll have a communication with the source that is partially confidential and partially not confidential. There, you have no choice but to withhold the whole thing, because giving it up and redacting the part that's confidential would show that that source was in part confidential. Um, I should make clear this under the Shield law, it's the identity of the source that you can protect, not what the source told you, unless what the source told you could lead to the discovery of their identity. So if I have an email from a confidential source telling me a bunch of information, and I can just redact the name at the top of the email, and nothing within the body of the text gives an indication of who the source is, then I would be able to provide that to the other side under the Pennsylvania Shield law. But the more you can leave a trace as you're making your notes and as you're writing, um, the easier it is at the back end to try to figure out what is and what isn't confidential. Um, I think there is Chris, you used some terminology off the record, on background. For the law, there's not a distinction. The key is, have you conveyed to the source a commitment to keep their identity confidential?
Yeah, that's a good point to make. You should always have an understanding, uh, ideally before the conversation, with the source about the nature of the conversation. Uh, that's something I've taken to doing. On the record means what they say can be reported, and their name can be attached to whatever they say. Off the record means you're using their information to inform your reporting, but you won't be putting it into the paper without further corroboration. And on background often means that you can use the information, but you can't quote the person by name. And in that case, it's usually a good idea if you can't get it any other way and it's important to the story, you should come up with an agreement with your source about how that source will be described without being named. And as always, you have to run that kind of thing by your editor. Everybody has to be on the same page.
And lawyer? Do you run that by your lawyer?
Don't take this personally, Eli, but hopefully the lawyer doesn't get involved.
Yep. So we had a question about sort of jurisdiction. I talked a good amount about how it matters what law applies. And the analysis for what law applies is complicated. Unfortunately, it isn't just sort of figure out where the journalist was. It's instead sort of figure out what's going on at the heart of the particular proceeding. So if you are um, in Pennsylvania, but you write a story about somebody who's in New Jersey, and they sue you for defamation, for the most part, the law that applies will be the law where the person who sued for defamation lives. So you could find yourself in Philadelphia, in Pennsylvania, writing about somebody who lives in Montana, right? Again, you might find yourself subject to whatever the laws are of the Montana, shield law to the extent one exists. So for defamation, it usually is where the plaintiff lives. Um, if you're called to testify in a criminal case, it depends who's charging the person with a crime, right? Again, you could have written about that person in Montana who's then under investigation by the Montana state government. Then, you'd be subject to whatever the privilege law is there. If you end up having information that's relevant to a Pennsylvania criminal prosecution, then it's going to be Pennsylvania law. If you end up having information that's relevant to a New Jersey prosecution, then it's New Jersey law. And you can't know ahead of time, unfortunately, what law is going to govern. It would make a whole lot more sense if it was wherever you're located, but that's just not the way that it works. Let's just see a question about how a confidential source, an agreement to make somebody a confidential source rises to the level of the contract. You are making an agreement with them. You're saying, you give me your information and I agree in turn to keep your identity confidential.
And it's interesting, have you actually had formalized agreements where you sign with confidential informants about that?
I'll let Chris talk about that.
No. I These things are usually done verbally.
Right.
I do sometimes though. I've been known people have emailed me things unprompted and said, "This is off the record." And I'll usually write back and say, "That's not how off the record works. Off the record is an agreement between all the participants in a conversation before the conversation begins." So, if you work for the city of Philadelphia or the government of Pennsylvania, you can't unilaterally invoke off the record. And I correct people on that, not to be a smartass, but because I think it's important that they know and understand the rules of the game that they're trying to play. Um, it's just, yeah, you don't want to go down that road where people decide before, during, or after that something's off the record when the journalist involved in the conversation has made no such agreement.
I'm wondering if when somebody sends you a document like that, have you ever had an experience where they send it from like some anonymous email almost so that you can't even figure it out as to how you've gotten it?
Yeah, that happens
Yeah.
a fair bit. There's a fairly regular occurrence of people trying to go no fingerprints on putting information out. Uh, and then, all the rules of journalism apply. You look at the thing, you do everything you can to determine one, if it's newsworthy, two, if it's real, three, if you should report it.
Eli, any other like pointers about I guess the type of information that can be protected in terms of protecting, the not just the reporter, but even the paper or the organization, a bigger picture. Like
Right.
what's the
So for the most part, the sort of shield laws and journalist privilege apply not just to the individual
right,
journalist, but to the organization as well. So it's
right.
not, you can't sort of go and end around Chris by asking his newspaper for sort of all of this stuff, right? So the thought is that there should be a freedom within the establishment itself to share information about confidential sources.
Right.
So Chris, may have had arrangements where he had to or did tell his editors who his
Right.
sources were. Sometimes maybe he didn't. I think it depends on the journalist and it depends on the institution, but um, the law fortunately recognizes that it can't be that just because you tell your editor who your source was, that means that you've somehow waived the protection that you otherwise would have had.
It's actually broader than the attorney-client privilege, so that's great.
Right. Right. It is in some regards. There's also no crime fraud exception to it, like there is for the attorney-client privilege. So it is when it applies, and we're talking about sort of the state shield laws, it's pretty ironclad.
That's
Uh,
that's that's important, right? It's really important. Okay. Any further comments, or we can? So, Chris, I want to thank you because I know it's not easy in this day and age. And so thank you for joining us and thank you for your dedication. It's truly appreciated.
Thanks
Eli,
for having me. It was a good
sure.
conversation.